We're going to go to Diana. The question is, with interest rates so low, what should I know about considering refinancing my home before my divorce is finalized? The deed and mortgage have always only been in my name and both acquired before marriage. So I know I have a comment, Diana, about that, but I'll let you take it over. It's from Daniel in Kentucky.
Hi, Daniel. So even if the deed and the mortgage were premarital, there's going to be a question if it's still marital property. So if there was any renovations done to the house, or if there were marital assets, which is money, put into the house, it could still be partially considered a marital asset. Now, if it is a marital asset, you obviously need the permission of your ex-spouse. But if you've already done it, or you're going to decide to do it without them, the courts will take that into consideration, and it's going to depend on when you sell the house. So if a divorce is already filed, it's going to be appraised as of the date of the filing anyway. If you are going to, a lot of people now are not trying, or are doing the forbearance because of COVID, the court is going to consider their circumstances at the time. But obviously, if it's a property that's yours, it's premarital, and your spouse has no interest to it, you are free to do that.
Yeah.
And Scott, may I jump in real quick?
Yeah, please. Go ahead.
I just wanted to add that when you file for divorce, your assets and debts, irrespective of the later determination of being marital or non-marital, they are under the court's microscope, subject to a claim by the other party, subject to court's divisions. That's why oftentimes, even on the judgment of dissolution, you do include non-marital property as being part of that judgment. With that said, it's always best, I would say, to first discuss that with the other party and see if you can reach an agreement, even if you believe that the property is non-marital property, just to avoid any issues. In case if the other party makes a claim that part of that property is marital, which it's only going to be the court that's going to determine that at the end of the day. Yeah. So to avoid any issues, just see if you can reach an agreement, which, you know, most likely benefits both you and your spouse in the long run.
And I think as enticing, just to kind of round that question up, is as enticing as the lower interest rates are, I think one of the considerations is what kind of free cash flow are you providing that may be used against you in child support and alimony, or even attorney's fees. You know, you don't want to walk into a court or a trial where you've now lowered your expenses and provided more free cash flow, what we call net available income, right? What is your expenses? What is your income? And what's the difference? We want that to be zero or negative. Most guys are living paycheck to paycheck, and they're charging everything, and they're running up credit card balances. That's a position where you kind of want to be in some respects. It's although be it financially bad, it's good from a family law perspective because you don't have a lot of free cash flow. A lot of states look at your ability to meet your own expenses first before they analyze spousal support. A lot of states differ, but that's something really to consider, whether or not it's a good move financially to lower your expense burden until this is resolved. Maybe you lock in the rate and you don't refinance until then. Something really, again, like everything we talked about today, seek the counsel of an attorney. That's really important.